We're not gonna start just yet. I'll wait till right at 30. Richard. Right, good afternoon, everyone. It's Wednesday, June 30th. These are the detention hearings for the 323rd Judicial District Court of the State of Texas, Tarrant County's assigned juvenile court. The purpose of these hearings is to consider whether or not a child who's been previously detained should first, whether or not the probable cause exists to believe that the child is engaged in delinquent conduct. In making that determination, the law allows the court to consider hearsay evidence in the form of police reports submitted to the juvenile probation department that are then forwarded to the court. The purpose of the probable cause determination is not to determine whether or not the child actually did what he or she is accused of, rather whether or not probable cause exists to believe that the child may have engaged in delinquent conduct. If the court finds that probable cause exists, then the court will proceed to a determination of whether or not the child should be ordered to remain in detention. In making that determination, the Texas legislature has outlined 5 different factors and considerations the court must take up in making that determination. The court will follow those factors in making that determination. If the child is ordered to remain in detention, then the child will have another detention hearing within 10 business days. I will remind the audience that this is a court proceeding. You're expected to behave yourselves accordingly. If you cannot behave yourself accordingly, I ask you to leave right now. I will also let everyone know that as a convenience to the public, in keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube, except what is counseled against by Section 5408 of the Texas Family Code. Anyone who may be watching these proceedings on YouTube, I will admonish you that recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. So the kids here today for detention hearings, each of you has the right to remain silent and not say anything at all. Anything you say during the detention hearing cannot be used against you at a future adjudication, disposition, or modification hearing. However, we do have representatives from the district attorney's office who are here listening. And anything you say, even if you think it might be meaningless, might lead them to additional evidence that they could use against you. Rather than just blurt out something, I would advise you to first talk over with your attorney what you want to say. That way he or she can advise you on whether or not you really should say it. You each also have the right to an attorney, and I will appoint an attorney to represent each of you during these hearings. First, we have Otter Razak Al-Bakhtari. Mr. Al-Bakhtari, the court has previously found the probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. The court is aware of the underlying allegations surrounding your initial detention. The court is also aware of your prior history of referrals to the Juvenile Probation Department. I will note that you are level 1-0 for the last 7 days. So, Mr. Gladstone, what are your thoughts?
Judge, he's been here and detained 165 days. The vast majority of those have been level 1 or 1-0. I don't know what else he would do to establish some kind of trust that he could be released. His trial's coming up in about a month. It's going to be a jury trial that involves a lot of folks out in the community. It's a great assistance to me if he was out on a monitor and under home arrest to help me with this matter. It's going to be detrimental to him if he's locked up for the next 30 days. That's going to be released.
Thank you, Mr. Gladstone. Given his history of referrals to the department and the underlying allegations, especially the complexity of the planning alleged to have been involved, the court does not yet feel comfortable releasing him at this time, so I'm going to order his continued detention. Thank you, Mr. Gladstone. Mr. Ballard. Yes, sir. All right, Mr. Ballard, the court has previously found the probable cause is illegal. But I also know that you're currently on probation, and on the 1-year pleasure of probation. Sometime last year, memory serves. You have been level 1-0, got there today. So, Mr. Pearson, what are your thoughts?
Your Honor, we just have to be released under the supervision of his parent, and I remember her very well from his before his question probation. She was very involved, very dependable in terms of being in contact and always responding to my phone calls. I would think she would be suitable to supervise him until we have a hearing on this motion.
All right, given the offense with which he's placed on probation, it was a probation with placement that involved a firearm. Given that he's only been level 1-0 as of today, I don't yet feel comfortable releasing him. So I'm going to order his continued detention at this time. Mr. Ballard, you want to maintain level 1-0 so that you can convince Judge Gill. All right. Thank you, sir.
Thank you, Your Honor.
Thank you, Mr. Pearson. Mr. Macias. Mr. Adler, do you mind moving on? Yes, the court has previously found the probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. I will also note that you achieved level 1-0 as of this morning. You're currently on probation out of Judge Terry's court, and am I correct? His modification here is not set till August.
That's right.
All right.
Yeah.
Later. All right, Mr. Macias. I don't feel comfortable releasing you today, but here's what I'm going to do for you. Mr. Adler, will you let Mr. Sierra know that he can schedule that modification hearing at an earlier time?
Judge, if I may, the reason that it was scheduled
Yes.
was because we were doing a cycle now,
Okay.
and it doesn't come back until late in July.
Has he completed the initial evaluation?
You know, it's scheduled for July.
Okay. All right. All right, Mr. Macias. if you maintain level of 1.0 between now and the 18th, I will authorize your release on the EM and sweat patch after you finish your evaluation. All right, but you gotta maintain level 1.0 for me between now and then. Can you do that? All right. All right. Thank you, Mr. Evans. All right, Raimundo Rojas. Yes, ma'am. And our, see the parent guardian.
Yes, sir.
Mr. Rojas, the court has previously found the probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. I will note that you've been level 1.0 since the 11th. That's a long time to consistently maintain this. Very, very good. Mr. Adler, what are your thoughts?
Judge, the parents are here. I realize how serious the charge is. No more serious charge. But I would ask that he be released on the electronic monitor, strict house arrest. Mom doesn't work, she'll be at home 24/7. She'll definitely call the PO if he violates. Full disclosure to the court, Judge. At our previous detention hearings, I think Judge Kim made it known that he would be ultimately making the decision on the release during the detention hearing. So I don't even know if you have any point to that.
Yes. You also know me well enough to know that it's not just the mere charge, but it's the allegation regarding the planning that went behind the offense that so scares me. But I'm not discounting the fact that you did level 1.0. This is your 20th day in a row. And that does mean a lot, because that shows you know how to follow the rules, and the longer you do that, the more likely it is for Judge Gillen to believe that if he sends you home with your mom, that you maintain level 1.0 for her, and that's what he would expect. It's a no from me today, but if you keep doing what you're doing, eventually you're going to tip that balance in your favor. Does that make sense? All right. Thank you, Mr. Edwards. Ms. Willingham. Yes, ma'am. Ms. Willingham, the court has previously found the probable cause of this to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. You're currently on probation, is that correct?
Yes,
All right. And I think I wasn't I the one who placed her on probation?
yes, and
That's
that's also been the last week.
Right. Is mom here?
No, she has work, she's been wanting for her to be off on the
All right. Good news first, Lizzie. What's your level on that? That's really good, because it's not easy to be a 1.0 and be a girl back there. I totally understand that. I would appreciate that, because I know a lot of it's not easy, right? Because like some of them try and egg you on and try to get you to mess up, right? But you're not falling for those tricks, are you? All right. That's what I need from you. All right. Because I need you to turn that corner for me. Because in the past, you know, some of those girls, you might have like fallen for the tricks, right? And that would have gotten you in trouble. But now you're showing that you know how to do the right thing, right? All right. I need you to keep doing that. I don't have mom to release you to today, so I have to keep you here. But when is her next hearing?
She said before you next Wednesday, around 2:30.
Okay. I will see you next Wednesday. All right. Keep maintaining the level 1.0 for me, because that goes a long way into the decision I'll make this Wednesday. All right. Thank you.
Apple to
Yes, ma'am. Ms. Barons, how are you? All right, Ms. Byerly. Good afternoon, Ms. Davidson. All right, Ms. Byerly, the court's previously determined, actually, here, because you're already on probation. Judge Terry, did your last modification, I think, is that correct? Okay. And then the modification before that, I did, I think. So, Ms. Burns, what happened to the refuge?
It's actually lower.
Oh, I'm sorry, I'm sorry, Ms. Burrell.
I'm not sure if she's, Bobby here, but, she absconded from the refuge, and so they.
Jacobson. Help me. Oh, and before I forget, happy belated birthday.
Thank you.
Your Honor, as you know, she just turned 17, and she feels that while she was at the refuge, she wasn't getting advances she properly should have. My understanding, she just made it to DFW recently. Her plan was to go home and stay with her mother. I was able to contact her mother earlier today. She's not able to make it to today's hearing. But it's my understanding that she would want her home and during a request that she go home.
All right, can't let you go home today. I want to be able to talk with mom first, all right? You know what you need to do in the back, right?
Yes, sir.
What's that?
Down.
All right. Probably Judge Kim's gonna make that decision. So you're gonna have to prove to him that you earned that right, all right? Thank you.
Thank you. So that's one way.
I know. I know. I don't think we can get there. I'm trying to create a solution. Thanks. Yes, sir. Yes. You filling in for Greg? All right. All right. Mr. Thomas? All right, Ms. Brazel, what brings Mr. Thomas to court today?
Isaiah was referred in custody by the First Police Department for unauthorized use of a motor vehicle and evading arrest. According to the officer report, officers observed an accident at the intersection of Precinct 9 and Pipeline Road. It appeared that a 2004 Malibu occupied by 3 black males had run on red light and struck a 2012 Suburban. Police observed 3 black males exit the Malibu, and Isaiah was the driver. Also in the vehicle were 1 juvenile and 1 18-year-old male who had it. It was wanted on a felony warrant. The officers told the 3 males to have a seat in a safe area while he worked the accident. A short time later, the officer observed the three males walking away, and the officer was told by dispatch that the Malibu was stolen out of Texarkana. Other police units arrived and the three males were took off running. A short time later, they were detained. Also found in the Malibu were Melinda Mathis and 6 girls later identified as acetaminophen and coke. And then Isaiah was brought here to detention.
Right. Based on the information provided, I will first find probable cause exists to believe that he is engaged in delinquent conduct. Does he have a parent guardian here
I
today?
spoke to his mother this morning. She was having difficulty with her vehicle. It was in the shop. She was trying to rent a vehicle to drive down here. And that was the last I heard, that she was at the car rental place when I spoke to her last. And that was about 8 o'clock this morning.
Is mom in Texarkana?
She lives in Texarkana, I think so.
Okay, Arkansas side or Texas side?
Arkansas.
Okay. Violet, what are your thoughts?
Yeah, I don't know, we don't show any extensive, history with, the court at this, child. So I will request that he could release, if mom is able to get here, to be released maybe on an electronic monitor.
Well, we can't send him on a monitor to Arkansas.
Oh.
This is not his first referral.
No, sir, he's been referred once before.
But he was rejected. So it's not that he was not
Okay.
adjudicated.
Okay. All right. Mr. Thomas, I don't have anybody to release you to today. And before I feel comfortable releasing you, I'd want to be able to talk to your mom. All right. Have they explained the detention levels to you in the back? Level 1, level 2, level 3? What's the worst level?
Level 3.
What's the best level? And within level 1, there's several sub-levels. What's the best sub-level? Okay, so we got level 1 acceptable, level 1 outstanding. Which is the best? Which one's the best? Outstanding or acceptable? Outstanding is the best, okay? I need you to get to level 1.0, because unless you're level 1.0, I'm not gonna release you, all right? So you need to get there, and you need to maintain that. And then we'll see, if mom can get here. I'll let you arrange a time, and see when she can get here, and then you can have an attorney requested detention hearing. But if you're not level 1.0, I'm not gonna release you. All right. All right, anything else?
No, no.
All right, that concludes today's detention hearings. Thank you, everyone.
Thank you, Your Honor. You'll state the excuse. Thanks.
I have one.
Oh, Frank did it for you.
Oh, Tracy?
Yeah, you can just use it on the court.
Oh, okay.
Sorry.
It didn't go in order, I guess.
Yeah. Did you? Yeah, you were here just for your last meeting. It just come through.
Okay, all right, thank you.
Well,
Mhm.